All this shady paper shuffling and document destruction, all of that calls to mind another high-profile case that has become virtually synonymous with obstructing an ongoing investigation. And it involves a company called Enron, a Houston-based energy company whose fraud scandal became one of the most famous high-profile cases ever of obstruction of justice. It happened 21 years ago, and it had everything. Corporate executives serving prison time, employees shredding and destroying documents, and one now defunct company caught up in that scandal, Arthur Andersen, Enron's accounting firm.
The indictment claims that on October 19th, Andersen learned Enron was under investigation. And soon the shredders at Andersen's office at Enron ran virtually nonstop for a month in what was called an unparalleled effort to destroy evidence. Shredding also occurred in Chicago, Portland, Oregon, and London. Andersen's response today? Defiance. In a statement, it calls the obstruction of justice charge baseless and a gross abuse of government power.
It took a federal jury 10 days to find the accounting giant guilty of obstruction of justice. And while the conviction was later overturned by the Supreme Court on a technicality, the Enron and Arthur Andersen scandals, as well as similar large-scale corporate frauds at WorldCom and Tyco, they all led Congress to pass, and George W. Bush to sign, the Sarbanes-Oxley Act in 2002. That law instituted a number of reforms, clamping down on corporate fraud. One of those reforms was this statute, 18 U.S. Code Section 1519. It tightened the penalties for destroying or concealing any record with the intent to obstruct just about any federal government function, including investigations. Section 1519 is one of the three criminal statutes the Department of Justice cited in its application for a search warrant for Mar-a-Lago, obstruction of a federal investigation. So there is an active question about whether or not the stuff Andersen and Enron did 20 years ago is akin to what Donald Trump has been doing with this new criminal investigation. Is it the same kind of obstruction? The illegal kind? What's clear is that Donald Trump certainly has some explaining to do. For starters, we learned from the unsealed search warrant documents that the Justice Department believed, quote, evidence might be destroyed if the warrant's existence was made public. And from the FBI affidavit, there was, quote, probable cause to believe that evidence of obstruction will be found at Mar-a-Lago. The FBI affidavit explained how for months the National Archives sought to recover the documents from the former president without success. Remember, the archives didn't get those initial 15 boxes of documents until January of this year. Why did it take Trump so long to hand over those documents? Why did one of Trump's attorneys sign a statement telling the DOJ in June that, to the best of their knowledge, all classified documents had been handed over when that was obviously not the case? Why did Trump allegedly not keep the remaining documents preserved in the storage room at Mar-a-Lago under lock and key, as instructed, shortly after that June visit from investigators? Why did subpoenaed surveillance footage later show, according to the New York Times, people moving boxes in and out and, quote, appearing to change the containers some documents were held in? And why, again, after that June visit from investigators and after months of back and forth with the DOJ and the National Archives, why were troves of classified documents still at Mar-a-Lago on August 8th? And why were they in Trump's office and in his bedroom in addition to the storage room? Why not just cooperate with the investigation?